Hello, everybody. I wanted to take a minute. We had a major Supreme Court case that hit last Friday with the overthrowing of Roe versus Wade, and unfortunately, we're in the middle of the summer. But I wanted to cover some things that I would have covered if we were in school. These are some things that we would have talked about if I were with my students that next Monday after this ruling. There's a lot of confusion, there's a lot of rhetoric, there's a lot of misunderstanding about what this decision means and why it was there in the first place. So for my students and for you, anyone that wants to watch this, I want to clarify some of those things and talk about what's really going on here. So I hope you find this useful. I hope you share it with your kids, with some of my former students, because there's a lot going on here. So to start, I would start with some background on the Constitution. So when the Constitutional Convention was held, colonists were suspicious of a large or a strong federal government. They'd just gotten rid of a king, and they were not in any mood to rush into another situation like that. So they wanted the Constitution to give just enough power to the federal government to keep the Union safe, to help the states stay safe, to keep the country operating well. And so in the Constitution, they listed certain powers that the federal government could have, such as collecting taxes, paying federal debts, regulating commerce with foreign nations and among the states themselves, establishing laws for becoming a citizen, coining money, setting up post offices, setting up copyright and patent laws, punishing piracies on the high seas, declaring war, and others. This is all from Article 1, Section 8 of the Constitution, and the executive branch also had certain specified things. I'm not going to go into every single one of those, but the idea was, here's what the federal government can do, and that's it. They wanted everything else to be decided and figured out at the state level. States were supreme back then, and they were very hesitant to give up any more power than they needed to. So one of the powers, or abortion, simply was not one of the powers that was granted to the federal government in the United States Constitution. It's just not there. So now, when the Constitution was ratified, there were many people who were concerned that there wasn't a Bill of Rights. So they agreed that the first Congress would put together a Bill of Rights, and they did, and we get that in the first 10 amendments. The first Congress passed that. So these are the things that we're used to hearing about. Congress can't set up a government religion, a state or government-sponsored religion. You have the right to free speech and to assemble peacefully. You have the right to bear arms for your protection. Government can't come and house soldiers in your house if you don't want them to and without your permission. No more cruel and unusual punishment. So, no more drawing, hanging, and quartering people, and as a punishment for treason. But the right to an abortion is not one that ever appeared in the Bill of Rights. It's just not there. Now, the last Bill of Rights, Amendment number 10, was a little bit different from the other ones. It says that any power that wasn't given specifically to the federal government in the Constitution is reserved for the states and for the people. So other than that limited list of things, limited list of jobs that the states were giving the federal government, everything else stayed with the states or stayed with the people themselves. Abortion simply was not a federal power granted in the Constitution. It was not a right that was protected in the Bill of Rights, so it's a state issue. And it was that way until 1973 when Roe versus Wade was decided. And we'll have more on that in a minute. But first, we need to jump to the Civil War. After the Civil War, in 1865, Amendment 13 was passed, which abolished slavery in our country. A huge, huge victory. Some states, though, ignored it, and they continued to deny rights to former slaves. So 3 years later, in 1865, Amendment 14 was passed, and here's what it says, and this is important because this comes to play, interestingly enough, in the Roe versus Wade decision. It says, "No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. So, this basically says these states that were denying rights to former slaves, you can't do that. You can't deny them of rights, and you cannot punish them or take away their life, take their liberty, throw them in jail, or deprive them of property, take their stuff away without due process of law. And due process of law is you get the right to meet your accusers, you get the right to a speedy trial, right? You have the right to go through this process that everybody else gets to go through if you're ever accused of a crime or anything else. You can't just have people throwing people in jail for however long they want just cause, without any reason, without just cause. So that's what that was meant to protect and meant to stop. Now, it took over 100 years and more until the civil rights movement of the 1960s and beyond to better live up to that expectation and that amendment. But that was the purpose of the amendment, of Amendment 14. Interestingly enough, if we fast forward now from 1868 to 1973, over 100 years later, the Supreme Court in Roe versus Wade stated that this due process protection really it carries with it an implied right to privacy, protection of privacy, which in turn itself carries an implied right to abortion for everyone in America. This case said that abortion is a constitutionally protected right. And here's what it says in Roe versus Wade. State criminal abortion laws, like those involved here, this was an abortion law in Texas that they were litigating, violate the due process clause of the 14th Amendment, which protects against state action the right to privacy, including a woman's qualified right to terminate her pregnancy. Now, I just read that due process clause to you, and it doesn't say anything about that. Doesn't say anything about terminating pregnancy. Now, remember, due process was about granting former slaves the right to the same fair legal practice as everybody else. This was not about abortion. And then Roe versus Wade goes on to create guidelines for what you can do during the first trimester, after the first trimester, and so on. And again, none of this was in the Constitution or the 14th Amendment. So this case basically invented rules and protections out of thin air. They didn't exist before. Other cases afterwards, like Casey versus Planned Parenthood, leaned on this decision and confirmed that abortion is a protected right in the Constitution. Now, I want to talk about the importance of intent when you're interpreting the Constitution. Roe versus Wade changed the Constitution and added a constitutionally protected right by reinterpretation and by some logical gymnastics. The problem is you have to look at the intent of the amendment at the time it passed. So to pass an amendment, you need 75% of states to agree. You have to have an overwhelming consensus that this is the right thing to do. Now, so you have to ask, when that Amendment 14 was passed, what did the majority of the people who passed that amendment think this meant when they voted to pass it? Abortion was not even on their mind. It was not a part of the debates in those conventions where this amendment was discussed. It wasn't the intent of that amendment, not by a long shot. Now you might ask, what's so wrong about reinterpreting the Constitution when societal pressures demand it? And the simple answer is, the Constitution can be changed, and it was made to be changed as society changes, but it was never meant to be changed by judicial reinterpretation. If you don't like something in the Constitution itself tells you what you can do about it and how you can fix it. And the way to do that is you get 3/4 of all the states to agree with you and you're home free. You get your change. You do not change it by getting 7 unelected judges, which is how many agreed to the Roe versus Wade decision, to reinterpret a 100-year-old amendment in a way that those who passed it wouldn't even recognize. All right. So what about precedent, right? Precedent is in the news a lot. We've overturned 50 years of precedent. How dare they? Precedent is sacred. And precedent is important in a legal system. lower courts in particular are bound by the precedent of the decisions in the higher courts. This keeps things predictable and stable, and it keeps people knowing what they can expect when they make a decision in their lives. The Supreme Court does consider precedent and leans on it heavily, but precedent is not a straitjacket. And in fact, that word precedent is not even in the Constitution anywhere. The Supreme Court's job is to ensure laws are constitutional according to their intent when the Constitution or the succeeding amendments were passed. So if a prior case blatantly violates the Constitution, which Roe versus Wade does, regardless of what your opinion is on the abortion issue, it does violate the Constitution, the court is honor bound, because they've all taken an oath of office to sustain and defend the Constitution of the United States. It's not precedent of prior cake courses, but the Constitution, that is their duty, sworn duty, they're honor bound to fix. And they were honor bound to fix Roe versus Wade. And fortunately, on Friday, June 24th, they did just that. In the Dobbs versus Jackson's Women's Health Organization case, they overturned Roe versus Wade and put the authority back in the state. So in summary, in a nutshell, abortion isn't a federal power. It's not in the Bill of Rights. For 190 years, how to handle it was left up to the states. And Roe versus Wade, in 1973, took that away, applied meaning to the 14th Amendment that was never intended to be there, and took that power upon itself to the federal government. The Dobbs versus Jackson's Women's Health Organization overturned Roe versus Wade and put the power to decide what to do about abortion back at the states in accordance and in alignment with the 10th Amendment. Once again, each state gets to decide what abortions are and are not allowed in their borders. Those who don't like that can change it. They should work to amend the Constitution rather than using intimidation tactics, threats of violence, or judicial reinterpretation to get their way. This is an enormous win, not because it will eliminate all abortions. In fact, there are many who think that it won't make much of a difference in the number of abortions at all. Maybe it will. We'll have to see what happens. Because the argument is people might just go to a different state. But this is undoubtedly a major win for the Constitution. Roe versus Wade unconstitutionally wrested power from the states. And the rule of law, not the rule of rulers or not the rule of 7 non-elected judges, is a big part of what made this country great. And seeing us return to the rule of law in this case is something to celebrate, regardless of which side of the aisle and which side of this opinion you happen to be on. I hope this was helpful. If you have any questions, put this down in the comments and let me know. If there are other topics that you've had questions about or would like to hear more information on, also leave that in the comments or reach out to me, let me know. Have a great day, and thank you for watching.